Good morning, everyone, and welcome to Gough Live. My name is Alison Hollis, and this is Jonathan Goulding, who will be taking you through two issues which were considered in the judgment handed down in the case of Platinum Crown Investments Limited and NE Essex Magistrates Court. Our live chat system is in operation, so if you do have any questions or comments for us, please do chip in, and I'll be monitoring as we go along. Over to you, Jonathan.
Well, thank you very much, Alison. If we could put up slide 1, please. Today, we're going to be discussing two matters. First, recent developments on the topic of charging the wrong defendant. Secondly, the correct procedure for interlocutory appeals on matters of law from the Magistrates Court. Both were considered in the recent case of Platinum Crown Investments Limited against NE Essex Magistrates Court. Slide 2, please. We discussed the topic of charging the wrong defendant on August the 17th last year in episode 2 of Gough Live. During that episode, which you can still view on the Gough Live YouTube channel, it was emphasised how important it is to ensure that the right, not the wrong person, is before the court. In particular, we looked at the difficulties that might occur with corporate defendants and considered the key case law in this area. The Platinum Crown case can now be added to the lexicon of these cases. Let's have a quick recap before looking at that High Court decision, which was handed down at the end of last year. In any criminal case, it is fundamentally important to get the right person before the court, obviously. This applies whether or not the defendant is a company or a natural person. But it's been in the corporate situation where most difficulties have been encountered in this area. The case law over the years has made a very clear distinction between situations of a mistake of identity and a mistake as to the name of a defendant. If there has merely been a mistake as to the name of a defendant, otherwise properly before the court, there is unlikely ever to be a problem. Amendment will certainly be allowed to change the name of that person. However, amendment is not possible where the wrong person is before the court. It is an incurable defect, with the big problem for prosecutors being caused by time limits that exist in most regulatory offences. If the discovery of the wrong defendant happens after the expiry of the relevant time limits to institute proceedings, then that is that. No fresh proceedings can be commenced. There is simply no power in criminal proceedings to amend a charge or information to substitute the correct defendant for the wrong defendant. And if we could please have slide 3 up. The earlier authorities all considered the situation when the facts demonstrated that the correct defendant was not before the court at all. The principle emerged from these cases that where the wrong person has been summoned, amendment should not be allowed, but where the prosecutor has correctly identified the defendant but merely misstated the name, amendment should be allowed. This happened in the Marco Croydon case, which concerned unlit skips, the Aldi case, which concerned bananas and pricing, and the Sainsbury's supermarkets cases, which was about dodgy jam, donuts and unsafe food case. In each of the three cases, there was a complex corporate structure. In each, the prosecution identified the wrong company and paid the price by finding out when it was too late. It was well put by Mr. Justice Latham in the bananas case, and he said that the statutory power to amend under section 123 of the Magistrates Court Act is a restricted one and applies only where a defendant makes objection to the information. It follows that section 123 has no applicability where the defendant before the court was simply saying, "It wasn't me who committed the offence, it was someone else." This isn't an objection to the form of the information, it's a defence to it. And he said that the consequence of allowing an amendment to substitute a different entity was, and I quote from his judgment, was to have an amended information charging out of time an offence against a different defendant. There's no power to do that. Slide 3 again, please. This trilogy of cases, skips, bananas, donuts, they were considered in the Essence Bars case. In the Essence case, the Court of Appeal Civil Division identified the relevant test as being A, whether it is clear that there is no mistake as to identity, and B, that the other party is not in any reasonable doubt about this, even though the wrong corporate name was used. In this case, an appeal notice against a licence revocation in respect of a nightclub wrongly named the licence holding company, but rightly described the appellant as the licence holder. The First Instance Court and the High Court felt bound by the earlier three cases, but the Court of Appeal felt able to distinguish them and review the test. Lord Justice Beatson said there is no automatic rule that a mistake concerning a corporate entity is a mistake of identity, or that where a name and a description is used, it is the former rather than the latter which identifies the parties in question. Thus, where a name and a description were used in a document, the description could be used to identify the party in question. The mere fact that there were two corporate entities involved did not mean there was a mistake of identity which could not be corrected pursuant to the powers in section 123. If the court is satisfied that there is no mistake as to identity, then the other party must not be in any doubt about it. In the Essence case, namely the licensing authority having documentation in their office that showed the licence holder was in fact Essence Bars Limited. Now to the Platinum Crown case, which again considers this issue. Can we please have the fourth slide? The facts are simple. It was a housing case. The prosecution laid 10 informations against Platinum Crown Limited, PCL, contrary to section 234 of the Housing Act 2004. Informations were also laid personally against the director, Mr Thomas. On the 21st of June 2016, Mr Thomas appeared in court, both as director of PCL and in his own personal capacity. He entered not guilty pleas. On the day listed for trial in January 2017, both Platinum Crown Investments Limited, PCIL, and Mr Thomas were represented by counsel. A large bundle of documents was produced by the defence, appearing to show that the building was leased to PCIL as opposed to PCL. The lesser of the premises was Mr Thomas. This documentation was designed to advance a defence for Mr Thomas, and not at that stage because there was any realisation of an issue as to mistaken identification of a corporate entity. The trial was adjourned to April because of the late production of this information. On the day of the trial, and for the first time, the validity of the informations laid against PCL was challenged on the basis it was the wrong defendant. The prosecution accepted that the name was incorrect, and they successfully applied to change it to PCIL rather than PCL. This was on the basis that the defendant's correct name had been misstated. The defence unsuccessfully had objected on the basis that because PCL was a separate legal entity from PCIL, the court were substituting a different person as defendant. This had the effect, they said, of bringing fresh proceedings against a different party outside of the limitation period. The defendant appealed this decision. It is useful for practitioners in their area to see how the High Court applied the law from the earlier cases to the facts of this case. The court noted that in the first three cases, the Skips, Bananas, Donuts, the prosecutor had proceeded against the wrong member of a corporate group, and that in those cases there had been a mistake as to identity rather than a misstatement of name. The court then considered the Essence Bars decision, which required there to be no mistake as to identity on the facts and also no doubt as to the identity of the defendant from the enforcer's point of view. The court also re-emphasised that such cases necessitate a degree of factual inquiry before the court could distinguish between a mistake as to identity and a misstatement of name. In the Platinum Crown appeal, the High Court, after stating the test to be applied, looked at the facts relevant to the case, and it's useful to look at those. These were, first, on the day of the informations being laid, PCL was a defunct company. Secondly, before the informations were laid, the local authority had been in correspondence with Mr Thomas personally and in his capacity as director of PCIL, not PCL. This included him being invited to nominate a representative of PCIL to be interviewed under caution. Thirdly, a previous statutory requisition for information was signed by Mr Thomas on behalf of a trading name of PCIL. Fourthly, at the first court hearing in June 2016, Mr Thomas, as director, entered pleas on his own behalf and on behalf of the entity described as PCL. He could only, the court found, have entered such pleas on behalf of PCIL. Fifthly, in January 2017, counsel appeared instructed by Mr Thomas and PCIL. Sixthly, at no stage was any person before the court representing PCL, and no one entered a plea on behalf of that company, which was defunct. The court found, based on this factual inquiry, that the local authority had always intended to prosecute PCIL. Further, it found that PCIL and its director, Mr. Thomas, were aware of that prior to proceedings being instituted. It found that this was not a case where there was any room for confusion with some other entity, as in the first 3 cases. Ultimately, it was clear that all parties acted on the basis that PCIL was the defendant, and that it was not appreciated until a late stage that there was a problem with the name of PCL on the informations and summons. The court analysed this as a case not involving a mistake of identity, but rather a misstatement of name. It said that what is required in such cases is an examination of the available evidence in deciding which side of the line the case falls. In this case, the High Court decided this was clearly a mistake as to the name, in circumstances where there could be no reasonable doubt as to the identity of the defendant by the court or the defendant itself. The appeal was dismissed. It's a case that demonstrates that, hopefully only very occasionally, prosecutors are still getting names, if not the identity of defendants, wrong. The simple message must be to get it right in the first place. Otherwise there'll be a challenge, and it will require a factual inquiry by the court to determine whether there's been a true misidentification or merely a misnaming. This in itself will take up prosecution and defence resources and court time at first instance, and maybe, as in all the 5 cases we've mentioned today, on appeal in the higher courts. The question of the correct procedure for appealing such a decision was also considered in the Platinum Crown case. What happened in the case was that the defence applied to the High Court by way of case stated from the decision, but on an interlocutory basis, i.e. before the trial on the merits had been determined. Slide 5, please. The High Court confirmed that generally there was no power for it to deal with an interlocutory appeal from the Magistrates Court by way of case stated. This affirmed the decision in Streams and Copping, where the High Court said that the Magistrates Court had no power to state a case until they had reached a final determination on all matters before them, i.e. determined the trial on the merits, having considered whatever evidence was adduced. The court in that case did say, however, that a concurrent right existed for a defendant to challenge an adverse finding concerning jurisdiction by way of judicial review. However, even then it considered that it would be rare for that to be done pending determination of the substantive case after jurisdictional issues were sorted out. In other words, for reasons of saving time and money, everything should be heard first in the magistrates, and then on appeal, at least in most cases. PCIL had ended up as an interlocutory appeal by way of case stated, despite the High Court previously saying the Magistrates' Court had no jurisdiction to do so. In considering Streams and Copping, the High Court considered that a strict application of the rule in this particular case would be likely to cause delay, additional expense, and might result in the same point returning to the High Court in the future if the magistrates convicted. It considered that all the materials before the court, the issue identified, and that the parties were ready to proceed after having spent time and money in preparation. The court saw no benefit in declining to rule on the point. It therefore dispensed with any formalities and treated the appeal by way of case stated as a matter brought by way of judicial review. In doing this, the court was affirming the degree of flexibility advocated in other High Court cases following the Streams and Copping case, permitting the High Court to deal with such appeals by way of judicial review in exceptional circumstances. This, however, should not be seen as a licence for interlocutory appeals to be routinely made in circumstances where all the issues at first instance have not been considered. Far from it. It seems to us that the Magistrates' Court should be made aware of these authorities. They should always decline to state a case in such circumstances and only rarely adjourn the further hearing of the substantive matters pending an application for judicial review. The High Court itself may then decline to grant permission for the judicial review taking place. It may only be, therefore, in clear cases where the substantive issue has been identified and it's supported by clear factual findings that it would be entertained. However, it can't be ruled out that at some stage in the future this issue will exercise the High Court again.
Well, thank you for that, Jonathan. We've had a few questions come in.
Good.
Not through the live chat, but over email.
Right.
So perhaps if we could take a look at those.
Yes.
The first question, has the Essence case changed the landscape in this area?
I think it has. I think before the Essence case, if the wrong corporate identity was brought before the court, i.e., Sainsbury's Supermarkets Limited instead of Sainsbury's PLC, you'd concentrate on that. Who, if they were indeed separate entities. But now, what Essence does is it says you should have a factual inquiry as to whether or not that was intended, whether what had happened in the investigation, and you look at all those factors to see whether, in fact, the intention was all along to charge the wrong company, and then a mistake was made as to its name. So it does make things easier for a prosecutor who's got it wrong, but with the caveat you don't want to be there in the first place. So it comes back to obviously get it right, try and identify the right person and call them by the right name early. Otherwise you may well have this satellite litigation where you are asking for adjudication on the factors to whether it is misidentification or a misnaming.
Indeed.
So Essence does. So the answer to the question is yes, it has changed the landscape, I think, from the way that the approach was in the 3 earlier cases.
Certainly. And the second question, what circumstances might properly be described as exceptional such that a judicial review might be warranted?
Well, I think that it would probably be the sort of situation where there weren't any or many substantive issues to be tried. So, for example, if the wrong company point was the only point that a defendant was running, in those circumstances, if you could say to the court, look, before we go on and finish this case off, we want to go for judicial review. But I think that it will be rarely used in my judgment. And I think that the lesson to be learned from these cases are for prosecutors and also the defence, because they're under a duty to bring these authorities to the court's attention, is to canvass them and say, look, this is what the law is, but we are saying, in this case, this is an exceptional circumstance where it's going to save time and money if we go up and get this sorted out now. So,
absolutely.
yes. So are there any more questions, Alison?
Let's ask the audience. Do you have any more questions? Send them in through the live chat. I don't see any coming through.
Right,
so I think
okay.
that's it, Johnny.
Great. Well, thank you very much, Alison, and thank you all for tuning in.
Yeah, join us again in 2 weeks' time for the next instalment. We'll see you then.